Hey folks, Eric here, the whatever guy, because it really is whatever with me. And do you folks want to know about my reasoning or my opinion is that we need to start over with the Alabama medical cannabis licensing? You guys stick around, man, and we'll talk about that. As you guys know, my name is Eric. I am the whatever guy. And you shoot videos a couple days a week, basically keep you guys updated in the world of Delta 8, Delta 9, Delta 10, hemp cannabis is what's going on in the realm. And today, man, it's in here bullshitting around looking at an article from actually back in October. As you guys know, we've got a lot of crap going on with the Alabama Medical Cannabis Commission as it stands right now. We are under a temporary restraining order for the medical dispensaries and under a temporary restraining order for the integrated facilities. And as we move forward, man, it just seems like the AMCC, the lawyers for the AMCC have been played by the lawyers of the applicants. I mean, they have basically going to discuss the scores in this here article here. This article is actually from back in October, but it's still kind of relevant right now of what we got going on right now. And in my opinion, like I said, the only way that we're going to get any resolution on these Alabama medical cannabis licenses is to either disband the commission and push it off to the legislature and get some sort of resolution there, or just start the process over from the very beginning, because it's been fucked up from the very beginning. Like, it's been effed up all the way around. Like I said, the applicants' lawyers have basically played the lawyers for the AMCC like a drum. I mean, they basically got them to agree to throw these scores out, and then they basically got they did get a TRO because they threw the scores out. So the process has been screwed up from the very beginning. So that tells you that from the get-go that now we have lawsuits on both sides of it. You got lawsuits for people, wanting the scores. You got lawsuits for people not wanting the scores. And now you have a position where we want to depot and get some sort of evidentiary hearing from the AMCC staff. And as it stands right now, like I said, for the last week, that's what those guys have been doing. They have been hashing out back and forth. What type of evidence will the AMCC give over to the applicants? Obviously, the applicants want a lot of information that the AMCC doesn't want to turn over. And my understanding is that those rules or those conversations are not going very well. Like, as it stands right now, they are not even speaking. Like that the 2 or 3 days of speaking that they had, my understanding is that all that's going on right now is some emails shooting back and forth, and really they basically had a face-to-face, and they're not coming to agreement on anything. So that deadline for the 18th or 19th, when they were supposed to have that figured out, is dead in the water. Like I told you guys from the get-go, that date was going to be dead in the water, and now it stands that we're going to move forward to February 24th, where the judge will make a decision on what is going to happen with this evidentiary hearing, because they want to depose 6 of the commissioners, or at least 6 of the staff. We know for a fact that there are 2 commissioners that definitely want to be depoted. They are actually telling the applicant lawyers that they want to be depoted. They want to get this out in the open. They're tired of their reputations being impugned, and they feel like they don't have anything to hide, and they want to bring this out in the open. And they are also the ones that are basically giving us the information that the AMCC is scrambling. There are people like Rex Vaughn, John McMillan, that do not want this information out. They do not want you to know what type of things were going on in their head when they made these decisions. And as it stands right now, we're at a stopping point. Like, we are stuck. And I would imagine that on February 24th, the judge is probably going to side with the applicants because he's already said so. And then that's going to bring forward an appeal by the AMCC up to a higher court. And we're going to be a long ways off from these licenses. Like, for you people out there that are contacting folks looking for equipment and stuff like that, I would slow your roll, because we don't have any clue exactly what's going on right now. And as it stands right now, we're going to flip over this article over here at I believe this is over at the Alabama Reporter, and this is by Josh Moon. This is actually from October, but a lot of the art, a lot of the stuff that he brings up is still what we're dealing with today. It says starting over is the only way to get rid of the stench in medical marijuana process. It says there's only one way to get rid of that stench, and that's basically to start over from scratch. Something stinks in the Alabama medical marijuana licensing process. I think I've said that before, but the skunk weed-like stench is overwhelming now. The smell wafted out of Montgomery County Circuit Court Judge James Anderson's courtroom Monday afternoon, but it did not originate there. The source is the Alabama Medical Cannabis Cartel. More specifically, it is the flawed and absurd scoring process that the AMCC is strangely adamant about keeping in place, even after admitting publicly that it was filled with errors and miscalculations. Even after agreeing once pinned to the map by cannabis companies that have filed lawsuits, to restarting the process and giving all of the companies applying for integrated licenses another shot before the commission. Despite all of that, the AMCC still wants to use those flawless scores collected by graders recruited by the University of South Alabama and approved by the AMCC. They're fighting for it. In Anderson's courtroom on Monday, several companies asked the judge to toss those scores and forbid the AMCC from using them. The AMCC is adamant it is a must use them. But now we fall forward to a situation where it was about a month after this that the AMCC finally agreed, okay, we're going to go ahead and dump these scores because you guys don't want the scores. We're going to go ahead and dump the scores. We're going to move forward with these new regulations. And then, of course, we are in a position now where those same lawyers that wanted them to throw the scores out are basically back in court, and they got a TRO because you threw the scores out. So, like I said, they're caught in a crossfire. They can't do anything right. If they had done it right from the very beginning, we wouldn't even have had this situation right here. But now that the AMCC has screwed up the process with the Open Meetings Act all the way from the beginning, we might not see any resolution on this anytime soon. It says why? It says that's the question, isn't it? Why would the AMCC, which should have only the goal of selecting the best possible companies to receive the state's first medical cannabis license, want to keep in place scores that has already admitted are flawed? And make no mistake about it, these scores are flawed. Want some examples? How about a company, Hornet Medicinals, which is 51% owned by Alabama State University, one of the oldest historically black colleges in America, failing to receive minority applicant status? It was also deemed for residency issue. It's only been in the state for 150 years. Or how about a company from South Alabama that received a near perfect grade from one grader for a security plan and then received a failing score from a second grader, an unexplainable difference? Or how about the fact that some companies with fully operational facilities were given worse scores for facility plans that companies haven't even poured a foundation yet and that have no hope of meeting a 60-day production deadline imposed in the law? And that's been my argument from the very beginning. I just told you guys last week that I had a company that basically called me in the cultivating space or contacted me through LinkedIn that basically was looking for equipment to buy, when I know for a fact that there were companies out there that they were not awarded licenses that were already set up with the equipment ready to go. So basically what this boils down to is that company that got a license that doesn't have any equipment or any foundation poured or any building up ready to go has to get marijuana up on the shelf within 60 days. They don't even have the equipment or the building in place, and companies that were better set up than them did not get licenses. And now these companies that did get a license are going to want to buy the equipment from the companies that didn't get a license. How fucked up is that? Like how crazy would it be for you to own a company and have a building up, not get a license, and then a company that doesn't have a building up gets a license, wants to buy your shit? Like that's crazy from the very beginning. Or how about the fact that numerous companies' scores were negatively impacted by a file size limitation imposed by the AMCC, but not strictly adhered to for all the applicants? Like some of the applicants were given a workaround for this 10 megabyte file size, and other applicant companies were not. Like, I don't know if you guys know this, but by the time I shoot this video at the very end, I'm gonna be at 10 megabytes probably. This video is probably gonna be between 8 and 13 minutes long, and somewhere in there I'm gonna be at 10 megabytes. I wouldn't even have been able to share this file size or explain in this video in 8 to 13 minutes what my company was about, what I had set up ready to go, and I wouldn't even been able to input that because it was a file size limitation that would have basically cut off any type of information that I wanted to get over to those guys. Like, you had just enough information for your application, which took up quite a bit of the 10 megabyte file size. Any other information that you wanted to file in there was basically moot and not there. Like these AMCC commissioners did not have the full amount of information in them to make these decisions logically. Like they just didn't. These are the scores that the AMCC is fighting tooth and nail to keep in place. Those scores are worthless, and everyone even remotely associated with this process knows it, including the AMCC and its attorneys, which we already know that for a fact because, like I said, they did throw the scores out supposedly. So why are they fighting to keep them? During Monday's hearing, one attorney, Bill Espy, told Anderson that a single deposition of a commissioner would reveal a corrupt process. Two sources familiar with the process told APR that the corruption in question deals with ties that certain current and former AMCC members had with applicant companies and investors, employees who stood to gain from the licensure process. They're talking about Stephen Stokes. They're talking about former AMCC people that had shit going on with these applicants. And that was one of the persons was Stephen Stokes. He was the guy that sat on the board that basically wanted to, and he was also the president of the board at the University of South Alabama. He was the one that talked the board into basically seeding these scores, these applications out to the University of South Alabama. That's where we got the second scoring. We were supposed to get one from the MCC, one from those lawyers, or excuse me, from those graders, and that was supposed to combine a weighted score. But we've already figured out that that process was already screwed up in the very beginning, because we know Stephen Stokes was president of that board, and because of that, he was removed from the AMCC board. But prior to that, 1 week prior to the awarding of the second licenses, there was a motion that was brought forward by Lori Skelton that would have allowed the commissioners to sit down and speak to each one of these applicants and get some sort of understanding about what they had going on. Stephen Stokes killed that. Like, he did not want any of the commission members speaking or interviewing any of the applicants whatsoever, and that was the last vestige of what Stephen Stokes did to this whole process. He was tied to a lot of these applicant companies, and it seemed like Stephen Stokes, and as much as I hate to say it, I'm possibly related to the guy, that he was basically the one that was guiding these certain applicants to get the 10 megabyte workaround and all that. APR also has received documents showing that the AMCC, or at least individual members, was much more involved with the selection of graders than the commission has previously stated. In fact, the commission apparently had final approval of all graders and was involved in recruiting certain individuals to be graders, according to an email provided to the APR, which would make it particularly easy to manipulate this process from start to finish. We already know for a fact that the way they did, the way they hired the graders on for the University of South Alabama was really crazy. But we also know that some of those graders were actually given legs up so that they get into the grading process, and that is what hurt companies like Oz City Labs. They were the ones on the other side that, like, there was people out there that were actually hiring other people to write notes, letters, basically downing All City Labs, and then a bunch of these graders did the business on All City Labs over there, which would make it particularly easy. Because if there's one constant in life, it's this: if something in a government process doesn't make sense, figure out who's getting paid. The simple fact is the AMCC has failed spectacularly in this process, whether by design or incompetence or both. The commissioners have failed to do the bare minimum of research into these companies. They've never visited the sites. They've never spoken with the company's leadership. They barely reviewed even portions of their applications. Instead, they have allowed the process to be hijacked and corrupted, and now we're left with the current national embarrassment. The only solution here is to start over and actually do the job that the medical cannabis laws demand of the AMCC and the licensure process. It's the only way to get rid of that stench of corruption. Like, guys, like, that's my biggest argument. Like, this whole thing right here, there's 30 other companies that have basically passed medical marijuana in their states. We could have learned from them. Like, we could have seen the mistakes that they made, and we could have learned from them. Like, 30 other companies. Like, this is a national embarrassment. Like, this, every time I report on this, I have to think that there are people out there that think Alabama, I already think Alabama is a bunch of low country backwoods folks, and here we are, we're making the case for them. Like we can't get this right. We need the AMCC to get their hands out of this, and we need some sort of legislature process to give us free markets, because as I've said many times before, it's not like all of these companies can get marijuana up on the shelf within 60 days. As a matter of fact, a lot of the companies that were issued licenses in these lower tiers could not get marijuana up on the shelf in the 60 days. And that's relevant, in fact, because I've got companies, like I said, that are contacting me looking for equipment in the marijuana space that they should have already had prior to even putting an application in. There's no way that company is going to get marijuana up on a shelf in the 60 days, especially when it takes 60 days to grow a plant from the very beginning. So the minute they issued the license, you had to have that equipment in place, because you had to be able to just drop a seed in the ground, because it takes 60 days for marijuana to grow. All right, folks, whatever, guys, signing off, and I'll talk to you guys later, man. Love you. See ya.